Welcome back. Just moments ago, the U.S. Supreme Court issued a ruling in a case that weighs whether former President Donald Trump can be tried criminally for trying to overturn the 2020 election. Long story short, the book is not closed yet. Joining me now to take a closer look at this is constitutional law attorney David Coale. Good morning.
Good morning.
All right, so you read through this conclusion. What's the easy way to describe what happened?
So what Chief Justice Roberts did in his opinion was he set up several buckets.
Okay.
And said if there's a prosecution against the President of the United States, each allegation in the case has to be placed in one of four buckets. And then the legal framework that you apply to analyze whether it can go forward depends on that. The easiest one is if it's official action. And the court said if you're talking to the Justice Department lawyers and you're the President of the U.S., you're talking to your team. That's official. Off limits, can't be prosecuted. The other easy one is individual actions like talking to a crowd on January 6th, tweeting to the public on January 6th. That's clearly individual. That's fair game, subject to the ordinary rules of criminal prosecution. In the middle, there are a couple of gray areas, and that's where the court went through and had some criteria about is it official or is it not? How do we answer those questions? And it sent the case back down to do some more work based on this new set of standards.
Okay, so what does this do to the case against the former president?
Well, the immediate effect is to drop out allegations about Donald Trump conspiring with members of the Justice Department. Recall there was a little side drama about the acting attorney general being brought in to allegedly enhance this conspiracy that they were claiming in the case. That's going to be out. So now they have to go back and look at the rest of the allegations in the case through the prism that Chief Justice Roberts has told them to. First, determine whether it's an official action or an individual action. Then if it's a official action on the outer limits of the president's authority, key words, the government has to overcome a presumption, has to make sort of an extra showing that it's fair to proceed with the prosecution even though it involves governmental action. That's a little bit uncharted. We haven't had that framework before. It's a new thing. Of course, this is a new kind of prosecution, and it's going to take the lower courts a while to kind of work through all that and show their work to the satisfaction of the Supreme Court.
All right, so to say this is confusing is an understatement. So if you mentioned earlier, let's go back to one of those buckets you said where maybe he's standing at a speech, say, on January 6th. You said that would be fair game.
Right.
During that speech, we remember him talking about then Vice President Pence and talking about him doing that. Okay, well, that now is included in the first bucket.
That's it. So there are two different, so there's the two relatively easy ones. The trickier ones are talking one-on-one to people that aren't Justice Department lawyers. And the examples were Michael Pence is one.
Right.
That's the one that's on the outer limits. That's sort of official, but not so clearly official that it's absolutely off limits. That's the one where the government has to make an extra showing. Then you have the we're not sure. Is it official or is it individual? Let's say he's talking to Sidney Powell. Let's say he's talking to Rudy Giuliani, private attorneys, not government attorneys.
Right.
Not clear. And so there's a test for how you separate out official and individual. Once you settle that, if it's official, you try and figure out if it's in the inner or outer part of official, sort of a hierarchy. The buckets aren't all lined up next to each other, in other words. Some are higher up buckets than others.
So I think maybe the public wants to know, is it now, after this ruling, easier to prosecute a president, even when he is a former president, or harder? Clearly
harder. Some things are clearly off limits, and this business about a presumption is definitely an extra step that the government has to take if it's going to prosecute a former president. Now, in practice, we'll see what it does to these claims. Maybe it just drops out a few things. Maybe it's a fundamental problem. That remains to be seen. There's a lot of work to be done. But on the front end, it definitely tells everybody for generations to come, it's a very serious thing to prosecute a former president, and there's a lot of hoops you've got to jump through, and here's a list of hoops.
Well, and you mentioned this gray area in the middle. Is the litmus test gray, or is that a specific, we're going to figure out and make this not gray?
Well, that's, I think, the goal, is to try to figure it out and make it not gray. The threshold question is it an official action or an individual action? Are you acting as the president, or are you acting as a private citizen? Easy enough to ask that.
Sure.
And you can lay out some factors and have a test you're supposed to go through.
And they did this?
They did that.
Okay, okay.
Devil's in the details, though. I mean, actually applying even the most learned, intelligent test ever to real live facts with real live humans is always going to be tricky, and reasonable minds can differ. So there's going to be, when they do the homework, there's going to be a lot of people with views on how to do that homework for sure.
Boy, and I hate to ask a historical what if, but you know, I know a lot of people look back to the Nixon presidency. Would the changes now have affected anything then, or when you think about history to come, what happens?
It's very hard. Well, as to history to come, Chief Justice Roberts is writing for the future. He's hoping that this will set a standard that lasts for 50, 100 years for the next crisis that comes along. Applying it in the past, that's a very interesting question, because certainly there were actions that Mr. Nixon took talking to people in the Justice Department that were central to the claims against him. On a quick read of the opinion, those are problematic under this test. And so it will be very interesting for professors to go back and apply this, because I think the case against Mr. Nixon might not be quite as strong now as it may have seemed in 1970.
Yeah. All right, so the case against former President Trump, what happens now? How does that work? It
goes back down. It goes from this court to the D.C. Circuit, which will then pass it back along to the trial court at Washington, D.C., and they will get out their pens and start writing.
Okay.
I expect they're going to get a lot of briefs in from the parties about, okay, we got this new test. What do we do, guys?
Sure.
Tell us how we ought to go about this. They'll probably have a series of hearings and a very lengthy opinion that will come out of that district court in some months. It's going to take that long to work through all of this.
And you were telling me earlier the difference here in this case was public-private. Well, the other case that was decided, the social media case, also a question of public-private.
Exactly the same issue, different setting. The question there in a very high level was, what are these really, really big social media companies like? Google, Facebook, are they like the phone company or an electric company who we expect to just carry everything without looking at the content or what the reason? Or are they like you? Are they like a TV station or a newspaper who gets to pick and choose what message they give to the public? Here the Supreme Court said, that's the question. Are you like a common carrier, or are you a private actor? But guys, this record, it's not enough. You guys got off on this thing about content moderation, and there's way more these people do than just that. Go back and do it over, looking at the full panoply of all the things. That puts a finger on the scales that very much favors the social media companies, but it just is a reminder that answering that question of public versus private can get real broad in the modern times that we live in.
And doesn't really, at this point, come to a hard conclusion, I suppose.
No, I think it's a definite hint about where the conclusion should go, which is, once you start down this road, it's a really long road, given how pervasive this is. But again, it's going to be some more homework, although here there's a little more nudging than there was in the Trump case.
All right. We'll continue to follow it. David Coale, appreciate your time this morning. Thank you. All right, Evan.